Welcome to Lawsymptoms. I'm Ravit Singh, a third-year law student at the Gujarat National Law University, Gandhinagar, currently interning at Lawsymptoms. The topic that we are going to be discussing today is the amenability of the Preamble of the Constitution of India. But before we get to that, let us first try to understand what a preamble actually is and if it's actually a part of our Constitution. So, the preamble is like an opening statement. It sets out the basic aims and objectives of the Constitution. The preamble of the Constitution of India sets out the structure of governance in India and the aims that were to be achieved by independent India. Today, most constitutions in the world begin with a preamble that embodies their key features and objectives that are essential in forming that constitution. Having understood that, let us come to the question of whether the preamble is a part of our constitution or not. Now, initially, the stand taken by the Supreme Court in cases like the Berubari Union and Exchange of Enclaves v. and the Kerala Education Policy were that even though the preamble helps us to understand important provisions contained in the Constitution, it cannot be regarded as a part of the Constitution and thus cannot be said to be a source of any statutory power. However, this stand was changed by the Supreme Court in the Kesavananda Bharati vs. State of Kerala case, wherein the court held that the preamble is actually a part of our Constitution and that the stand taken by the court in the Berubari Union case was in fact wrong. In Union Government vs. LIC of India case, it was held that even though the preamble is an essential part of our Constitution, it cannot be enforced in a court of justice. Having settled this, let us now come to the question of the amenability of the preamble. Now, as we all know, that initially the Supreme Court had held in the Berubari Union case that the preamble is not a part of the Constitution. So when the question of its amenability under Article 368 first arose in the Kesavananda Bharati case, it was argued that the preamble not being a part of the Constitution cannot be amended under Article 368. However, the stand was rejected by Justice Y.V. Chandrachud, who held that it is impossible to claim that the preamble is not a part of the Constitution. Building upon this, Justice Palikar held that the preamble being a part of the Constitution can in fact be amended under Article 368. Justice Beg held that the power of constitutional amendment provided under Article 368 provides no limit to the power and that it can be used freely to amend the Constitution. Thus, through the majority, through its judgment in the Kesavananda Bharati vs. State of Kerala case, established that the preamble being a part of the Constitution can be amended under Article 368 like all the other provisions of the Constitution. However, the court observed that it was necessary to maintain the basic elements of the preamble, for removing any of those would actually lead to a change in the basic structure of the preamble, which would modify our Constitution and it would not remain the same Constitution as it was before. Till date, the preamble has only been amended once by the 42nd Amendment Act of 1976, whereby the words socialist, secular and integrity were added to the preamble. To conclude, we can state that the preamble is like an initiating statement of the Constitution that lays down the objectives and principles upon which that Constitution is built. Initially, although the Supreme Court was of the opinion that the preamble is not an essential part of our Constitution, the stand taken by it was changed in the Kesavananda Bharati vs. State of Kerala case, wherein it was held that the preamble is actually a part of the Constitution of India. Finally, The Kesavananda Bharati case also established that the preamble, being an important part of the constitution, can be subjected to an amendment under Article 368 of the Constitution, the only proviso being that its basic structure should remain unchanged. That's all for today, guys. If you enjoyed the videos and would like to watch more such content on law, please do subscribe to Lawsymptoms. Thank you.